This is a continuation of our accommodation, ADA accommodation series. Mental health accommodations in particular have skyrocketed the last few years. And in our last episode, we talked clearly about what the process looks like you have to follow. So check that out. But what I want to focus in on this episode is reasons why you do not have to grant an accommodation. Last episode, we talked about the 5 step interactive process that you need to go through, and then the 3 most common reasons you don't have to accommodate. And those were undue hardship, eliminating an essential function, and you don't have to provide the preferred accommodation, just one that meets the needs. Okay, so those 3 are things you want to look at from the lens of your accommodations. What is an accommodation? It's a change to a schedule, job function, anything related to a medical need. Okay, again, go back to the last episode, it's going to key you in on that. When you look at other reasons that you don't need to accommodate, one that comes up all the time is leave. So, employee gets in a car wreck. They can't come into work for a certain amount of time, or they can't, a better way to say that is they can't perform an essential function of the job for some time. You do not need to give them indefinite, open ended leave, paid or unpaid. Leave is a common accommodation. Indefinite leave is never an accommodation. An important case on this is Severson versus Heartland Woodcraft. Check it out. It's from the Seventh Circuit. After 12 weeks of FMLA, and whether you're an FMLA company, that's another episode. Normally that applies to 50 employees or more, but let's just assume that you're, a reasonable person and you're like, hey, I know you can't come into work for the next 12 weeks because of this injury, illness, whatever. I'm going to hold your job for you. You're not paid during that time, but FMLA, there are different rules, but you're just a smaller company and you say, I'm going to hold it open. You set an end date for how long you're going to open up. After 12 weeks, in this case, that the employer said, no worries, come back when you're healthy, but they granted it in 1-month blocks for 3 months, up to 12, in their case, it was up to 12 weeks for FMLA. But in your case, say, cool, update me in 30 days and we'll look at this again. All right, cool, update me in 30 days. We're looking at this again. All right, look, man, we got 30 more days. We're at 12 weeks now. You got to come back to work. The employee wanted another 2 to 3 months after that. The court upheld the termination. A multi-month leave of absence is beyond the scope of reasonable accommodation. The ADA is an anti-discrimination statute, not a medical leave entitlement, is a direct quote from that court case. The principle everyone agrees on: if there's no reliable return date, you can't plan coverage, you can't hire a replacement, you don't have to hold the job open forever. So, a definite time limit extension that lets them return to essential duties is reasonable if that's not an undue hardship. But I don't know when I'll be back is not a reasonable accommodation anywhere. Managing HR in-house is overwhelming. That's why we built the People Processes Advisory System. Start with our free HR resource library, get instant access to policies, guides, and compliance checklists. The templates are just the beginning. Run our strategic HR audit to scan all your key domains for your people processes. In just a few hours, we'll work through and identify your compliance gaps, and my team will generate a custom roadmap for you, meet with you, and show you exactly what to fix step by step, ready to execute. Use our toolkit to generate job profiles, deploy policies, track employee documents. You're not alone. You're backed by a 5-star expert team supporting over 10,000 employees nationwide. Be your team's secret weapon. Visit advisor.peopleprocesses.com to start your free account today. So when someone comes to you and says, hey, I got this medical issue, I can't come into work for some time, the interactive process is cool. How long? What's your plan? And you grant it in a step, and you say, all right, look, small business, I've only got 10 techs. You're asking for 1/10 of my techs to be off for a month, and me not hire somebody else to replace you. I can do that 1 month. All right. I will accommodate that. But I can't do this forever. So you've got to keep me updated. And if you can't return to work in a month, I'm not going to be able to keep you. I'm going to have to hire somebody else. Okay. That's a reasonable back and forth. Now you discuss it with him. It's like, well, can I get a month and 3 days? Fine. Right. If you're able to do a month, you're probably able to do a month and 3 days. But if he says, I don't know, man, whenever I'll be back, I'll be back. That's like, no, I can't approve that. You're going to be terminated. Reapply. All right. talk back and forth. Another key thing is direct threats. This is a common one that comes up. Whether it's an essential function or not, you don't have to keep or accommodate someone who poses a direct threat, a significant risk of substantial harm to themselves or others that can't be reduced by a reasonable accommodation. This is a narrow escape hatch, not a catch all. It requires an individualized, evidence based assessment on four factors. Normally, you have to ask a doctor: duration of the risk, nature and severity of the harm, probability it occurs, and imminence, the likelihood. Like, is it going to happen tomorrow? You cannot invoke direct threat based on stereotypes that people with like a mental illness are dangerous. The EEOC is actively scrutinizing this in 2025. So, like a speculative or remote risk doesn't qualify. It has to be documented and real. Here's a legit example: a machine operator whose condition causes sudden loss of consciousness around dangerous equipment. No accommodation is going to mitigate that risk. Or a daycare worker who's got responsibility, one teacher, three kids, infants, and they have something that causes them to pass out, right? And you ask the doctor, all right, well, like the epilepsy, something like that, where they may have a seizure or things like that. It's like, okay, doc, how do we make sure that doesn't happen? And he's like, well, if you make sure the room is cool and the kids don't scream and nobody gets upset or she does any physical activity, the likelihood is small, but could still happen. It's like, I can't accommodate those things. And, a 1 in 10 risk over the course of a month that she's going to have a seizure. Like, this is dangerous. Direct threat means you can't accommodate. The sixth limit after direct threat and indefinite or open-ended leave, and of course the three we talked about in the prior episode, is qualification. The ADA only protects a qualified individual, someone who can perform the essential functions with or without accommodation. This goes to that essential functions role. If they can't perform an essential function even with a reasonable accommodation, there's no obligation. A delivery driver loses the ability to drive. No accommodation restores it. There's no vacant non-driving role that they're qualified for that you'd love to have them in. Your obligation's over. You don't have to create a job, bump another employee, or promote them, right? It's about the job's essential function they're in. They have to be qualified to be able to do it. The driver is a good example because sometimes commercial driver's licenses, CDTs, the driver's test, those things have higher standards, right? And if they can't meet the standards of that driver's license or nursing license or whatever, they're no longer qualified for the position. Okay. Finally, last two, we have lowering their standards or excusing misconduct. Employees with disabilities meet the same production and quality standards as everyone else. The ADA does not require you to lower your bar. It requires you to look to see if you can do something that's not an undue burden to make sure they meet the bar. You never have to tolerate or excuse violence, threats, stealing, or destruction of property, even if the misconduct is disability related. I have great anxiety, had an anxiety attack, threw your computer across the room. If you discipline a non-disabled employee for the conduct, you can discipline the disabled employee too. You must apply it uniformly. Accommodation is prospective, not reactive. You may have to help them meet the standard going forward, but you don't have to excuse past misconduct. So think of it this way. If it's something that you would give a written warning or verbal warning or a suspension for to someone else, and you would do that, and then they respond, well, man, the reason I did that is because I have this disability. All right. You wouldn't have fired the person because they did that thing. There are many people you didn't fire for that. You suspended them. You wrote them up. You would still suspend or write this person up, but then you would enter the interactive process to try and see if there's a way you can make sure it doesn't happen in the future. Okay? You don't have to excuse past misconduct. You have to figure out what you need to do going forward. An employee with a mental health condition yells at a coworker. You can impose the same discipline you'd impose on anyone. The disability does not immunize the behavior. It just requires that you enter a process to see if there's something you can do to make it so they can keep their job going forward. All right? Yelling at a coworker, normally, depending on what is said and how often they've done it, it's not a fireable offense, right? It's something where you get really upset with them. You may write them up, but you're probably not going to fire them. Although if you're in your organization and you've got 5 people, when they yelled at another coworker, you fired them. And then this guy yells at another coworker, that's it. Fire him. Follow the same. It's not about past disciplinary matters. Final limit is reasonable documentation. Especially on mental health, this is difficult. When the disability and the need for accommodations aren't obvious, you can require reasonable medical documentation. You're entitled to confirm one, there is an ADA disability, and two, that it necessitates the accommodation. You can ask for documentation of the nature, severity, and duration. You cannot demand the complete medical file or unrelated records. If the documentation is insufficient, explain why and give them a chance to cure it. You're not stuck taking a bare assertion at face value. If the disability and need are obvious, you don't need documentation. If the guy got his leg cut off, you don't need a medical record showing, like, well, what can you do with one foot, right? Or like, what did you lose a foot? You don't get medical records you don't need. It's a dangerous thing. Again, going back to that daycare example, right? Someone's having epileptic seizures. I don't know if that means that we need to change, that she's like, look, I have this sometimes. And it's like, okay, well, can you do your job and keep kids safe and yourself safe? I want a doctor to tell us that. Okay. If your doctor can't tell us the intensity and severity and the likelihood of this thing being a problem, you won't give us any documentation about it. We can't let you get into a class with little kids. So not getting documentation, just relying on their words, if it's not obvious, you need to get some documentation. All right. Now let's talk about the most important thing to understand. The ADA is designed to be proportional to your business. The undue hardship standard is not any cost you don't like, but it is measured against your actual resources. A small business legitimately reaches significant difficulty or expense much faster than a large corporation. By definition, the reasonable accommodation you're required to provide is not an undue burden. The two are opposite ends of the same standard. If it's reasonable, it's not an undue burden. If it's an undue burden, it's not required. Most accommodations are cheap or free. So I want you to think about that. If you're looking at something and it's somewhat, it's a little annoying to communicate, to change, like a schedule adjustment, permission to work from home 2 days a week, a quieter workspace, a modified break schedule. Those sorts of things are the most common accommodation. The Job Accommodation Network, JAN, Jan, a free resource will help you figure them out. I'll link to them in the description as well. They have a bunch of potential accommodations. If the employee can't come up with any, you can direct them there, and they'll be like, oh, this is what I need. The expensive lawsuit scenario almost never comes from accommodation itself. Like, I've seen people push back and do these sorts of accommodations and that and that. Rarely. I mean, historically, it's so rare for it to come from the accommodation. It comes from refusing to have the conversation. The common $125,000 settlements that are just popping out 80 times now, just constantly, are for employers who say, we treat everyone the same, and slam the door. Okay? So, the way you stay safe is these key things. Individualize. Do the actual case-by-case analysis for each request. Don't apply a blanket no. Be uniform in applying your conduct and performance rules the same way to everyone. Disciplining a disabled employee for conduct you tolerate in others is discrimination. Consistency in your standards protects you. So, if, again, someone has these sorts of things, you have to worry about retaliation. And the only thing that's going to support, if, they tell you they need an accommodation and then they stop showing up to work, is consistent history, or they show up late over and over. Consistent history showing sort of like what you've done in the past in the same situation. It's one thing to say for a week, we're going to work on this while we work through our interactive process. But once someone's made these claims, you have to really make sure that your documentation, not just on this employee, but on other adverse actions, terminations, demotions, schedule changes, is done well, because they're all going to be part of the case if you wind up having to fire this person a week after they ask for an accommodation. Okay? Individualize, be uniform in your standards, and then document every conversation, every option presented, every decision, and every reason. Uniformity plus documentation is what wins these cases. Okay? You individualize the accommodation, but you stay uniform on the standards. That is the key. You don't bend the quality bar for or conduct rules. You don't have to do that, but you have to follow the same process for everyone and then look for an individualized accommodation for that one person. The average ADA settlement's $125,000. It's normally 2 years' salary. Okay. If it goes to jury, like if you refuse to settle, millions, tens of millions, happens all the times. The cost of a documented interactive process is a couple of hours. Just get it done. Figure out what they want. Look at the things. Are they reasonable? Can you do them without undue hardship? Does it interfere with their primary job duty? A 30-minute documented conversation versus a $125,000 settlement. That's the math. Okay? Do it. Do it. All right. In the description, I've built an ADA interactive process toolkit for you. It's at our advisor.peopleprocesses.com site. It gives you the step-by-step interactive process guide, an accommodation request intake form, a documentation template, and a part to help you when you don't have to accommodate decision guide that walks through all 8 of the limits that we covered today and last episode. It also has a 30, 60, and 90-day monitoring checklist for when you put in place an accommodation. It's a great toolkit, advisor.peopleprocesses.com. If you want a professional to look over your entire accommodation process along with the other 17 domains of HR compliance, we're offering our strategic HR audit for free for the first 10 companies each month. Go to advisor.peopleprocess.com in the description and use episode EP75 audit. That's Echo Papa 75 audit, episode 75 audit as your coupon code. So you log in, you go to the top left, you click on audit, strategic audit, go to checkout and use EP75 audit in order to get these for free, just 10 per episode. And in fact, episode 75 is this and last. So everyone on these 2 accommodations, I'm only doing 10. Here's what I want. You need to have 10 employees and be a US-based business, and I would love to work with you. It's a way for me to get to know you guys, give you some great value, and I hope you take advantage of it. Here's what I want you to walk away with. The ADA is not a bottomless pit. It shouldn't be something you're afraid of. It's a reasonable accommodation standard, with the word reasonable doing real work. You have to have the conversation. You have to look at what they need, and you have to do it individually. You have to document it. But you get to pick the accommodation as long as it's effective. You get to protect your essential functions. You get to hold your standards. And by definition, you never have to take on an undue burden. That is the key here. Now, in our overall series, our next episode is going to be about pregnancy accommodation under the Pregnant Workers Fairness Act, PWFA. It's a brand new law, just like 2 years old, that most employers have never heard of. And I'll see you there. Thank you for checking this out. I hope this helps you be a better employer, and for employees who are watching this to understand your rights and duties in these sorts of processes. I wish you the best of luck. Now go out there, have a great day, and get your work done.